Namaste and a very warm welcome from TIL Legal Tips. I am Sushila Ram Varma, Chief Consultant at the firm. Today's topic deals with how one goes about arbitration, that is, the arbitration process.
So, ma'am, we begin with our first question. Can you please share your thoughts on how can a person or when can a person start an arbitration?
Yes. Generally, when one talks about arbitration, it's a private method of settling all disputes. Now, an arbitration can only take place if both sides have already agreed that they will have a dispute resolution by means of arbitration. This agreement has to be in writing and has to be signed by both parties.
So, ma'am, how does the arbitration process actually begin?
The arbitration process begins when there is a dispute between the parties. In such a case, one of the parties sends a legal notice to the other party stating its desire to start arbitration and also putting in all the disputes that have arisen between the parties. Now, if in the arbitration agreement there is a clause which says how or who is going to be the arbitrator, then they can name that particular arbitrator in the notice and ask the opposite side to give consent for the initiation and starting of the arbitration.
So, ma'am, once the parties have exchanged, have sent the notice and have nominated an arbitrator, how is an arbitrator actually appointed?
Now, in the arbitration agreement that we were talking about, parties generally agree as to how they will decide on the arbitrator. Some parties think that they will have an arbitrator who will be appointed by an institution. For instance, it could be an arbitrator from an institute called Indian Council of Arbitration, or it could be some international organization like ICC, SIAC, etc. So this would be known as an institutional arbitration, where the parties would be bound by the terms and conditions or the rules that that particular institute has made, and they will follow those rules right from the beginning. That is, when they're issuing a notice of arbitration till the arbitration is concluded by way of an award. Apart from that, in an arbitration, you can have a designated authority or a person who will appoint the arbitrator. This generally happens in government contracts, where a very senior level person from the government has the power to appoint the arbitrator, and he or she then appoints the arbitrator as per the arbitration clause. Then there is a third mechanism, and that is any party who has initiated an arbitration, if there is no named arbitrator or no institute or no designated authority, they can suggest the name of an arbitrator. If the arbitrator is acceptable to the other side, then the arbitration can start. Failing which, the other side would also give a suggestion about the arbitrator that they would be interested in. If both parties are able to agree on a particular arbitrator, then the arbitration can begin with that particular arbitrator. Otherwise, the only option is that they move to court. Now, when you say move to court, it means that if the parties fail to appoint an arbitrator and start the arbitration proceedings, they can move the court under a provision called Section 11(6), by which one party can approach the court and inform the court that they are unable to appoint an arbitrator, and though they have an arbitration agreement, they cannot agree to a particular arbitrator. So then the court, in its understanding, will decide, depending on the subject matter of the arbitration, as to who should be named the arbitrator, whether it's a single arbitrator or two arbitrators or three arbitrators. And then the parties will have to start the arbitration in front of that sole arbitrator or the arbitral tribunal, as it is called.
Very well. So now that the arbitrator is already appointed, ma'am, can you please share the steps that are actually that follows the appointment of arbitrator?
Yes, once an arbitrator is appointed, the parties generally do not have a schedule fixed as to how they will go about the arbitration process. So that schedule is decided by the arbitrator when both parties are present. So the arbitrator decides what are the ways in which the dispute will be decided. He gives the option to the party that has initiated the arbitration to file a statement of claim or a claim petition. The opposite side gets a chance to file their statement of defense. Then the parties file the evidence. And if there are any applications for interim relief, these are also filed. And finally, the arbitration starts when the arbitrator listens to the parties, looks at the evidence, and then concludes the matter.
So, ma'am, given that the arbitration has to be concluded as per the schedule that is decided by the arbitrator and the parties, is there any particular timeline that has to be followed by the arbitrator to conclude the arbitration?
Yes. Harini, as per our Indian Arbitration and Conciliation Act 1996, an arbitration, if it's a domestic arbitration or an international arbitration, should be concluded within a fixed time. Generally, the time is a 1-year period, but in many cases, it is not concluded in 1 year. So the parties move applications before the arbitrator asking for an extension of time for whatever reason it may be. And then this timeline is increased or extended. But there is also something called a fast track arbitration in our law. And that fast track arbitration finds mention in Section 29 of the Arbitration and Conciliation Act. And it states that parties will conclude their dispute resolution by way of arbitration within a period of 6 months. So this is what is known as the fast track arbitration.
So now, ma'am, once the arbitration gets concluded with the passage of an award, can you please also elaborate to our viewers what is basically an arbitral award and what are the types as such?
Award is generally the finding of the arbitrator or arbitral tribunal regarding the disputes that are arisen between the parties and the decision given by the arbitrator. Now, awards can be of 3 types. One is an interim award. In the interim award, certain interim measures are given during the course of the arbitration, where one party may have moved an application for some interim relief. This could be any kind of relief. They could be asking for attachment of a particular bank account, or they could be asking for deposit of certain sum as security while during the proceedings are going on, or it could be an interim relief where some goods have to be sold to mitigate damages. After this, there is also something called a final award. In this final award, the dispute between the parties is concluded. Many a times, some disputes are left, although they have been raised, but sometimes for some reason, maybe it could be the arbitrator has missed it or the parties have not really gone into lengthy arguments. Then that particular aspect or that particular dispute which has not been decided then is also again decided by the arbitrator and it becomes part of the final award. Now, over and above that, if during the arbitration proceedings, the parties want to settle their disputes amicably, which they will always have a right to do during the proceedings, then in such a case, they come up with certain terms and these terms are then incorporated into the arbitral award. And this is what is known as a settlement award.
Okay, ma'am, now that the parties have received the award in paper, how do they go about enforcing the award?
Yes. Now, once the award is passed, it is deemed to be equal to the decree, to a decree of a court, which means that you can move for execution. Now, if a party moves for execution of the award, it can only do so after it has waited for the appeal period to be over. So, if it is, say, a 60-day period, then they will have to wait for the 60-day period. Now, what happens in the 60 days is that the party who is not satisfied with the award or the opposing party wants to challenge the award in a court of law and therefore moves an application under Section 34 of the Indian Arbitration and Conciliation Act. challenging the award. Then it is up to the court to decide whether to look into the award or not. Now, as this is a lengthy topic, we will keep it for some other episode, and I think we can conclude over here. In order to make this episode interesting, we have made it as a question and answer. And in case you have any further questions, you're welcome to put them in the comment box below. If you have liked this video or you have found it useful, I would request you to please like, share, and subscribe so that we are motivated to make many more such videos in the interest of public, and we can share more legal knowledge with one and all. Thank you.